Fauziana, your news reporter for this segment. In this session, we will discuss an important case that has captured attention, Mohamad Zulkifli Bin Ismail against Public Prosecutor 2020, Malayan Law Journal Unreported 1951. Let us begin with the facts of the case. This case was decided at the Court of Appeal Putrajaya on the 24th November 2020 before the three Court of Appeal judges, which is Justice Yaakob Muhammad Sam, Justice Harminda Singh Daliwal, and Justice Ravitran Paramaguru. This case was first tried at the High Court of Malaya, Kuala Terengganu. The key individuals in this case are Mohamad Zulkifli Bin Ismail, who is the appellant who brought this case to the Court of Appeal. He had murdered the deceased, which is Zulkifli bin Abdullah. There are four main witnesses in this case. Known to be the first one is the prosecution witness 17, Faizul bin Allah. The second one will be the prosecution witness 11, Muhammad Rozi bin Taib. The third one is prosecution witness 22, Yahya bin Azhar. The last one will be the prosecution witness 12, Dr. Srimani. There are two legal provisions involved in this case. The Section 302 of the Penal Code, which is a punishment for murder for causing the death of Zulkifli bin Abdullah, known to be the deceased in this report. Section 326 of the Penal Code, causing grievous hurt by dangerous weapon, in this case is machete. There are two principles involved in this case, which is known to be the mens rea and actus reus. The appellant's use of a weapon, a machete, to inflict a stab wound directly to the deceased's chest, targeting the vital organs, can be said that he did so with the intention to cause fatal injury. He continues to commit assault after showing an intention to kill. For actus reus, in this case, the appellant's action of stabbing the prosecution witness 70 and the deceased. The severity of the attack and the location of the stab wounds shows that the appellant's physical act would have caused death. Appellant's use in this case was firstly private defense. The appellant said that he acted in self-defense against prosecution witness 17 and the deceased, as he claimed that both the deceased and prosecution witness 17 attempted to attack him first. Next is accidental homicide, where the appellant argued that the stabbing of the deceased was unintentional and as a result of the deceased running into the weapon itself, the machete. Lastly, these are the cases referred to as authorities. Let's take a closer look at what eyewitnesses captured during the incident.
Apa ada orang mati ni?
Legal issues better in this case, our reporter, Iza, spoke to the public prosecutor who shared the insights on what the court will need to determine.
Yeah, could you explain what the main issue is in this case and what the court will need to determine regarding the appellant action? The court will decide whether the appellant's act amounted to murder under Section 302 of the Penal Code and whether the appellant's act amounted to voluntarily causing grievous hurt by dangerous weapon or means under Section 326 of the Penal Code.
The court had reached its verdict in this high-profile case. Let's go live to the courtroom for the judgment.
The appellant's act of stabbing the deceased with a machete, P47A, targeted a vital area containing critical organs including the lungs and major blood vessels. This caused severe blood loss and led to death as the most probable result. The deliberate use of a deadly weapon and the appellant's continued assault even after the deceased begged for mercy demonstrated clear intent to cause death under Section 300, paragraph C. The defenses of self-defense and accident lack evidence. The appellant claimed that the deceased attacked him with an iron rod, but no such rod was found, and witnesses confirmed the deceased was unarmed. The claim of an accidental injury is inconsistent with the deliberate force used and the appellant's continued assault after the stabbing. Similarly, the conviction under Section 326 for voluntarily causing grievous hurt is upheld. The appellant intentionally stabbed prosecution witness 17 in the chest as confirmed by forensic analysis of the machete and prosecution witness 17's testimony.
Now in, reactions pour in from both sides. Here's what the prosecution and defense had to say outside the courthouse.
What does today's decision mean for the broader application of Section 300 class in individual cases? In this decision, it affirms the importance of intent in cases of murder. The court found that the appellant's deliberate actions targeting a vital area with a deadly weapon met the criteria under Section 300, paragraph C. This sets a precedent for upholding justice where intent is clearly demonstrated.
And that concludes our special coverage of this case. This is Nur Afifah Fauziana reporting for Lex News Tonight.
This is the case of Mohamad Zulkifli Bin Ismail, a man whose actions would ignite a legal battle over intent, self-defense, and the boundaries of the death penalty. It began as an ordinary day for the prosecution witness and his companion. They were scavenging for metal scraps near the home of Mohamad Zulkifli. What happened next would leave one dead and one gravely injured.
So right now, we have one of the witnesses.
I saw him standing there, holding a machete. The deceased was sitting on the road divider, injured and unable to defend himself.
The evidence painted a chilling picture of the appellant's action. But was it an act of premeditated violence, or could it be justified as self-defense? In court, the appellant claimed that he acted out of self-defense. He alleged that prosecution witness 17 and the deceased posed an imminent threat, with the deceased wielding a 2-foot-long iron rod. Forensics, however, revealed inconsistencies in his story. No iron rod was found in the scene, and witnesses stated that the deceased only tried to help his injured friend.
This case hinged on the interpretation of Section 300 of the Penal Code, particularly Clause C, which focuses on the intention to cause bodily injury sufficient to result in death. The court referred to several landmark cases to arrive at its decision. Such case was Abdul Aziz bin Muhammad Sharif against Public Prosecutor. Here, the Federal Court clarified the distinctions in the application of Clauses A, B, C, and D of Section 300. These distinctions were initially outlined in the Singaporean case Jumaat bin Samad against Public Prosecutor. Chief Justice Yong Pung Hao noted that clauses A, B, and C require intention in varying forms. Clause A requires an intention to cause death. Clause B, an intention to cause specific bodily harm. And Clause C, an intention to cause bodily injury that is sufficient in the ordinary course of nature to cause death. Clause D, however, does not require intention but only knowledge that the act is likely to cause death. In this case, the trial judge determined that Mohamad Zulkifli's actions fell under Clause C of Section 300. The judge referred to Versus Singh against State of Punjab, which established the elements required to prove a charge under Clause C. 1. A bodily injury must be present. 2. The nature of the injury must be proved. 3. There must be an intention to inflict that particular injury which was not accidental or unintentional. 4. The injury must be sufficient in the ordinary course of nature to cause death, a determination based on objective evidence.
The court also drew parallels to Herman bin Muhammad Amin against Public Prosecutor, a case with strikingly similar facts. In both cases, the appellants used sharp weapons to inflict fatal injuries and were initially sentenced to death under Section 302 of the Penal Code.
Zulkifli's case, the Federal Court emphasized that it is not necessary for the prosecution to prove an intention to cause grievous harm. All that is required is proof of the intention to inflict the injury that was proven to be present.
Initially sentenced to death, Mohamad Zulkifli's fate changed with the passing of the Death Penalty and Life Imprisonment Review Act 2023, Act 847. The Federal Court reviewed his case, citing the abolition of the mandatory death penalty.
For review, this court annuls the death sentence imposed on Mohamad Zulkifli and replaces it with a 35-year prison sentence, effective from his date of arrest, December 7, 2015.
The passing of Act 847 allows for the Federal Court to review past death penalty sentences in light of recent legislative reforms such as the abolition of the mandatory death penalty. Under Section 3, Subsection 1 of Act 847, individuals sentenced to death can apply for a review in writing. Section 2, Subsection 4 grants the Federal Court the authority to affirm or substitute sentences in accordance with the that we have examined this case in great detail. We will now see how the case of Mohamad Zulkifli Bin Ismail against Public Prosecutor will affect future cases in Malaysia. Firstly, the judgment from this case sets a judicial precedent for death penalty cases to be reviewed under Act 847. Convicts previously sentenced to death may now have a stronger reason to file a review application where they can seek to resentence their long-term imprisonment. Consequently, the courts will need to carefully assess if death penalties in similar cases is justifiable or they should follow a sentencing that is proportionate to the case. Than that, the judgment from this case also demonstrates the importance of reviewing other rigid sentencing frameworks. Courts may advocate for more flexible sentencing options for serious offences to shift towards a judicial system that balances punishment with opportunities for rehabilitation. This sets a precedent for reconsidering the fate of individuals previously sentenced to death under outdated laws.
This case underscores the importance of intent in criminal law and the judiciary's role in adapting to legislative reforms. With Act 847, Malaysia takes a significant step towards a more nuanced approach to capital punishment.